First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon and welcome to the First District Court of Appeal. We have two cases on the docket today. We will take them in the order that they appear. Our first case today is Virginia Browder versus Hillsborough County School Board and Broadspire. Counsel, if you are ready, you may proceed.
Hey, police and court. My name is Nicolette Sambus. I'd like to reserve 5 minutes for rebuttal, if that's okay.
So noted.
I represent Virginia Browder, the appellant in this matter, the injured worker who was wrongfully denied her medical benefits with regards to her workers' compensation case. This is a question of law case where I believe both sides are in agreement with that. It involves a de novo review. We are asking this court to determine whether the JCC erred by failing to shift the burden of proof to the employer carrier for a clearly compensable injury, which is the left knee and the osteoarthritis, which is included within the left knee. Stated differently, this is a case where the claimant has a left knee injury. It's a stipulated left knee injury. Essentially, the employer carrier bought it at the store, and then 2 years later, they're trying to return it. And they've already bought the compensable condition, and the employer carrier did not have any evidence to break that chain of causation to no longer continue to provide medical care for this left knee injury.
And there's no dispute over whether the left knee injury is compensable, correct?
That's correct.
All right, so really the dispute is over whether whatever arthritis existed at the time that the claimant was first injured is, and what the osteoarthritis she was treated for later is the same injury, and whether that injury is compensable. Is that right?
Well,
or that condition?
Your Honor, the claimant has had a meniscal tear where she required 2 surgeries, right? And in the evidence with Dr. Campagnoni, there's evidence of some arthritis in the knee when he's doing those surgeries. Then the claimant goes from Dr. Campagnoni to Dr. Goldsmith, who diagnoses it with primary osteoarthritis. The only diagnosis in 2018 when the claimant sees Dr. Goldsmith in June of 2018 is osteoarthritis. That is the only diagnosis.
And it's a diagnosis, and the doctor says no treatment whatsoever is needed.
Well, see, I disagree with that. In the record, you'll see specifically on page, if you refer to Dr. Goldsmith's deposition testimony, you'll see that he treated the claimant in June 2018, and he recommended injections, ice, rest, and light exercise. He also notes, he also indicates in his deposition that he may have provided the claimant with a brace. And then you'll see in the claimant's testimony on page 23 of at the final hearing, she indicates that Dr. Goldsmith provided her with a brace, provided her with an injection, and saw her again in 2019, in April of 2019, where again, the only diagnosis is osteoarthritis. So it's not a case where the doctor says, come back, but there's nothing to do for you. He says, diagnosis osteoarthritis, I'm going to give you an injection. I'm going to give you a brace. He has a conference with the employer carrier and later says osteoarthritis is not causally related to the work accident. But again, that's in December of 2019. The employer carrier is well aware of the diagnosis, the only diagnosis being osteoarthritis. The treatment that was provided, the adjuster's testimony is that she paid for the treatment with Dr. Goldsmith. She knew of the diagnosis of osteoarthritis. She even knew of the conference that took place that was saying osteoarthritis. And they don't do a notice of denial to the claimant until a year later. That's a year later. So the osteoarthritis is a bought compensable condition by operation of law under 440-20 subsection 4. The statute indicates that the employer carrier has a duty to act, and I believe that that's been reiterated in a lot of the recent workers' compensation decisions by this court. There's a duty on the employer carrier's part to act, to be vigilant, to investigate. So here under 440-20, per the legislator, the employer carrier has 3 options. They can pay, they can pay and investigate, or they can deny. And they have the duty to do so within 120 days. And that clock starts when they have sufficient notice, right? So sufficient notice. What's sufficient notice? Well, here, back in 2018, Dr. Goldsmith diagnoses, the only diagnosis is osteoarthritis. It's the
And
only
that's
one.
at the same time that Dr. Goldsmith is also saying that the osteoarthritis can't be determined to be the result of the work injury, right?
That's what he says in the first DWC 25, the first report in June of 2018. He says undetermined osteoarthritis being causally related to the work accident or not. And then, later on, he gets to conference with the employer carrier and then signs a conference narrative. But again, that's still in 2019, and the notice of denial does not come until a year later.
So, I'm sorry. So it's everybody seems to agree that it's arthritis. It's not about whether or not it's arthritis. Dr. Goldsmith agrees it's arthritis. I think that's right. The question, though, is whether the arthritis is a result of the work injury. And Dr. Goldsmith doesn't conclude that it is. So why would that put them on notice with regard to this particular, the nature of this particular claim?
I don't think that's the question, Your Honor. I respectfully disagree with that. I believe the question is whether compensability has been bought. Has it been accepted by the employer carrier? There are numerous cases from this court. Specifically, there's the Jackson case versus Marriott Electric, where the back injury is degenerative disc disease. The question is, the claimant, in that case, the claimant had surgery on his back, and there was evidence of spinal stenosis, but the employer carrier continued to treat it for 13 years, and then they decide they're not going to pay for it anymore. Well, this is a case where the claimant has osteoarthritis in her knee. They paid for treatment. She's relying on this treatment now for over 2 years for her left knee, whether it be osteoarthritis, whether it was traumatically induced or not. That's the employer carrier's duty to investigate and their responsibility to act vigilantly with regards to providing benefits to an injured worker. And now to 2 years later, pull the rug out from underneath her is against the current case law, against the statutory provisions of 440 subsection 4, and against the legislative intent.
Where in 440 subsection 4 are you referring to? Because really what we're talking about is there's a difference between whether or not the employer carrier has to accept compensability of whatever arthritis existed. Does that then preclude the employer carrier from 2 years later looking at a claimant who's over 70 years old, diagnosed with osteoarthritis, degenerative arthritis? The employer carrier cannot come in and bring an IME first, and then an EMA that says whatever arthritis is here in this claimant, it is not caused by the workplace injury. The fact that they accepted the knee and some arthritis is compensable, does that then cut off the ability to prove that it wasn't related?
I'm not saying it's an end-all, be-all. I'm saying that according to the case law, there has to be a break in that causation chain. The chain has already been established here. Compensability has been established.
For some arthritis, but not, arthritis is there could be multiple causes, right?
Well, I'm not a medical doctor. And
Well, there were a couple that testified in this case, right? And they looked at her medical records, and they looked at it and said the arthritis that we're seeing now in 2020, 2021 is osteoarthritis and is not related to the work injury. Are they not entitled to opine, and is the JCC not entitled to rely on that?
The JCC is entitled to rely upon an opinion of the expert. And in fact, Dr. Swiggett was appointed as the EMA in this case. Dr. Swiggett opined that there's osteoarthritis in the knee and that her treatment that's needed is reasonable and medically necessary, the treatment that's recommended, and it's related to the osteoarthritis. He does not say at any point in time that as of December 21st, 2021, the osteoarthritis that was pre-existing took over from a traumatically induced arthritis. He doesn't, there's no evidence from the employer carrier to establish that break. So to answer your question, yes, the employer carrier can raise major contributing cause to specific treatment being recommended for a compensable condition. Here we have a compensable condition. They can establish evidence to break that chain of causation, and that break of the chain of causation could be caused by some intervening accident, could be something that they didn't know about, could be something that developed over time, maybe because of your age, but there's no testimony here. There's no testimony from Dr. Swiggett, from Dr. Goldsmith, that because the claimant is 70-plus years old, that is the break in the chain of causation, and now it's no longer a compensable condition. The employer carrier argued in this case that they accepted the left knee, they put on the pretrial stipulation on 2 separate occasions, left knee only. And I think that that's the first issue, is that they accepted left knee only. So they said they didn't limit their responsibility to the left knee. They didn't say meniscal tear only. They didn't say post-traumatic arthritis only. They just said left knee only. And then at that point in time, I believe they've accepted compensability. But even if you were to go further and require there to be the compensability argument based on the 120-day rule, there's 3 requirements for the JCC to go through, which the JCC did not even go through any of them. But the first is the date the EC first provided benefits, and that's when Dr. Goldsmith diagnosed with osteoarthritis, and they provided an injection, they provided treatment, they provided follow-up care, they didn't even look at it again for another 2 years. And then they have to identify the specific injury of benefits provided, and then did the EC timely deny under 120 days, and they did not. I know that I'm into my rebuttal period, but I'd like for this court to refer to the Sanchez case, which is a 2020 decision, where the facts are substantially similar to what's going on here. In that case, it was a truck driver with a stipulated low back injury. The EC offered no evidence that the diagnosed condition did not exist at the time of the stipulation. There is no evidence here from the EMA that says that osteoarthritis that requires reasonable and medically necessary treatment was not in existence at the time that they stipulated to compensability, or by operation of law that osteoarthritis has been compensable. This is not a case where we're requesting a total knee replacement or anything. It's a follow-up visit to the doctor and the treatment that's recommended by the EMA that's reasonable and medically necessary. So I'd like to reserve the remainder of my period for rebuttal, if that's okay.
Thank you, counsel.
Thank you.
Good afternoon. May it please the court. I want to start with the first comment raised by the appellant, that the facts were agreed to. Well, therefore, then we're saying that the judge's determination of the fact that there had never been treatment before for the osteoarthritis is agreed to. And I think the record bears that out. Your Honors have brought up some of that treatment. I want to just basically go over in the record, or lack of treatment, where that can be found. As the court indicated, in the first time they saw, Dr. Goldsmith saw Ms. Browder back in 2018, he indicated that her diagnosis was undetermined. He talked about the fact that he found it, he couldn't justify her objective findings with her subjective findings. He further went into some determination about the fact that he wasn't sure what she needed treatment for, meaning he may have recognized that she had a beginning arthritic condition. The lady was in her 60s at the beginning of this accident, and I think by the time this treatment was provided, she was approaching 70. Nobody would be surprised that she had arthritis to begin with, but what was never treated was the ongoing problem of osteoarthritis, the progressive problem that went over time. And that's where the dispute was. That
All right, and if I could just stop you, I want to deal with the appellant's counsel pointed out that there was a prescription for ice, rest, probably elevation, and a splint or I can't remember, bandage. So why isn't that enough to show treatment of the osteoarthritis?
I would refer the court to page 565 of the record. This is where Dr. Goldsmith's note says, and he later testifies to this, I don't show that I gave her an injection. As far as ice, rest, physical therapy, that had always been her course of treatment for the meniscal tear over time. And that was no different. I think when you go back and read that note, you're finding he's summarizing what's been provided for her in that first visit. He doesn't give her anything, and there is some. I know she testified that she got an injection. I don't show any evidence in his records about a brace whatsoever. And when he gave his deposition testimony, he specifically said, "I'm not certain where the brace came from." So to say that that is a prescribed form of treatment and we, quote, bought the condition really belies what the doctor's saying about his own treatment. He didn't do any of those things according to the medical record. And that's what the JCC relied on in his determination that there had never been treatment.
And let's just go through the facts a little bit. The claimant was placed at MMI in 2015, correct?
I believe so, yes.
Right. So, when the claimant goes to Dr. Goldsmith in 2018, gets the ice, rest, maybe let's for argument's sake say a bandage and an injection. Your suggestion is that could have been for the prior knee injury and not necessarily the arthritic condition?
I am, and I'm saying that because he puts in his DWC that it's undetermined. He's having a hard time of is her need for treatment now this osteoarthritic condition, or is it the meniscal tear? So looking at it from the standpoint of the employer carrier, there is no definitive way for them to say, we need to cut off treatment. What we did was, this is a pre-existing condition, dormant, if you will, minimal arthritis. Every one of us has arthritis at a certain age. So over time, it becomes more of an osteoarthritic condition that needs treatment. That's what Dr. Goldsmith's getting at, and that's what's finally determined by the EMA, the need for the EMA.
And so why isn't that enough? The existence of this maybe dormant, not needing to be treated arthritis, why isn't that enough to trigger the pay and investigate 120 days at that point?
Because we agreed with the meniscal tear. We did not agree to the osteoarthritis. There is no we bought the farm here, as appellant would argue. We were giving her the benefit of the doubt for the treatment for the meniscal tear, which had already had 2 surgeries. And we're moving forward. So let's go from the time frame from 2018 forward. She goes an entire year. Of course, our position is no treatment. When she goes back to Dr. Goldsmith in 2019, again, no treatment. He says he has nothing further to offer to her. And what happens next? She goes out and gets an IME. That's not treatment. That's a way of her creating a controversy. Then it was discovered that she'd never really had a change, her one-time change under the statute. So what she did was she asked for that. And I think we properly analyzed in the briefs that she's entitled to that. So she gets her one-time change. And then we get to Dr. Tedder. We're now into beginning of 2020. We're talking about this 2-year lapse in there. There's no treatment provided in there. Dr. Tedder comes along. He still, in his first May 2020 evaluation, doesn't say anything about whether or not she's got osteoarthritis or the tear. He says, I don't have enough records. I want to get her an x-ray, and then I'll see her back. So fast forward from there, we file for an EMA, not because of what Tedder said, but because we have a conflict between what the IME Dr. Fiore said and what the prior doctor said. She now has osteoarthritis and she doesn't need treatment. The linchpin here is the word treatment. We believe, as the case law is indicated and as our brief outlines, and the JCC found, she didn't get any treatment in that period of time. We were not in a pay and investigate period until later. In fact, we agree with the JCC, as we argued at trial, that we are now in a position of major contributing cause. That's what's coming in here with the EMA. That's why we requested it. The EMA provided that opinion. We understand it can be overruled in some cases, but there's no evidence to show that. There's no evidence that any doctor says that she needs treatment for anything related to the accident other than the meniscal tear.
All right, and let's go back to 2018, and just hypothetically speaking, let's assume that the employer carrier accepted and treated some level of arthritis, whatever it is. Would that then preclude the employer carrier from showing without an intervening or superseding cause that the need for treatment in 2020 is osteoarthritis and a different type of arthritis than what the physicians were seeing in 18?
The treatment that she got in 2018, whatever it may be, was surrounding the meniscal tear. The MCC still remains available to us, and that's what we relied on, and that's what the case law is. That's what the Checkers versus Wutoff case says. That's what Nolan says, is that just because there's a compensable injury doesn't mean at some point we can't challenge the right for the benefit that's being requested. And the benefit being requested was the PRP injections from Dr. Tedder and I guess there were some Synvix injections. We're entitled to bring up that request and deny those things as the progression of the case comes, when it's no longer 50% the injury, it's 51% the osteoarthritis, different than her slight arthritis that she had even as far back as 2012. So just because we may know there's some problem there, it doesn't prevent us, according to the case law down the road, from denying benefits based upon major contributing cause. And I want to make sure the court understands that in the pretrial, while we did indicate it was left knee was her injury, that doesn't mean we buy every condition in her left knee from now till the end of time. What it's basically...
In fact, isn't that what Checkers holds?
Pardon?
Isn't that what Checkers holds?
Well, Your Honor, I don't believe so. I'm going to respectfully
No, I'm saying doesn't Checker support your position?
Yes, oh, absolutely, as does Nolan,
Because if the argument is once you treat a body part, you have an obligation to treat that body part for every ailment that flows for the rest of time, that can't be logically correct.
No, and Your Honor, is when 51% of the reason for that treatment now becomes another condition. It may have been there dormant. That's what our position is, that it was dormant. It was not made symptomatic. There's no testimony it was made symptomatic by any doctor. Even their IME doctor doesn't say it was made symptomatic by the injury. She went for years just treating the meniscal tear, and then the JCC found at the point at which we are at trial, because remember there were petitions involved in there before that aren't before this court, but each time in 2019 those petitions that were filed, the employer carrier always denied the benefit. What happened was there was an injection provided by Dr. Tedder at some point after he got this diagnostic, not authorized, and that's clear from his own testimony, and then the EMA comes along and the denial follows immediately. So even if we're going to follow this 120-day analysis, which I do not agree with, but if the court were to find that, we're in the time frame from when Dr. Tedder first provides that injection, October of 2020, to the notice of denial December 4 of 2020, well within that time frame.
So let's talk for a second about 440.24, this section setting out the 120-day
120-day pay and
rule.
investigate. Yes, sir.
So the language of the statute talks about a claim, 120 days from a claim that needs to either be denied or accepted within 120 days. So when you're saying the linchpin is treatment, what treatment is, how we view it, how we define treatment, is that because you're using the term treatment as sort of synonymous with claim in the language of the statute?
I believe the statute does talk about treatment, but I think it also says requested benefit. And requested benefit, in my mind, is the treatment. The benefit is the treatment for the condition, which we provided, as we're required to do, because she had a left knee injury. We bought the left knee meniscal tear. We did not say for the rest of her life anything that happens is going to be our fault. For example, nobody's recommended it yet, but what if she needed a left knee total replacement?
Right, and I think, again, Judge Long makes a good point. I mean, it's helpful to go back to the words of the statute. The very first clause of the pay and investigate provision says, if the carrier is uncertain of its obligation to provide benefits or compensation, what in 2018 would have made the carrier uncertain of its obligation to provide benefits. If it's operating under the assumption that it's providing benefits for the meniscal tear, and there's no recommended treatment independently for the arthritis, what would create uncertainty in that circumstance?
Well, I think, Your Honor, there isn't any reason for us to have provided anything else. I mean, at that point, she went a year. When she came back to Dr. Goldsmith, she still didn't get treatment of any form. Everybody's kind of focusing on 2018 and this injection, which I submit the doctor says it didn't happen. And she's had other injections. I'm not saying that she didn't understood she had some kind of injection, but the doctor's notes don't reflect that she had an injection in the 2018 treatment. The doctor's notes don't reflect that in 2019 she got any treatment either. And every petition filed after 2019, the specific benefit was denied.
So,
Go ahead.
no, go ahead.
No, please.
So, in trying to kind of hone back in on the language of the statute and in identifying what is the claim for treatment or benefits that has been made, at what point was there a claim for treatment for arthritis that was made at all?
Not until the petition that we're here on today that was denied by the employer carrier in this case.
So your position is that never at any point was there a claim for any kind of arthritis, for any kind of treatment for arthritis at all?
I believe that's correct, Your Honor, and you know, just for purposes of where that would be found, the judge in their order always goes through what the petition is asking for, and in the particular case here, the petition that was filed and the benefits that were requested were, if I could just give that real quick, pardon me for not having it up.
I don't need you to go hunting
Right.
for it, but that's my recollection of it also. I
Right.
couldn't find it in there either. I don't know where there
Right.
was ever a claim that was actually made for treatment for arthritis, which is the reason I asked the question.
Right.
And so I'll yield then.
And it is in that compensation order, claims are under paragraphs 1, 2, 3, and 4. No word osteoarthritis ever appears there.
And counsel, I see we're running out of time. I'm going to extend your time by 2 minutes, and I'll do the same thing for appellant. Can you explain where this common kind of referral to buying the body parts coming from? Because obviously nothing like that's in the statute. So when the employer carrier is buying something, is that something that is in a decision from this court, or is that just parlance within the workers' comp industry?
I believe, Your Honor, it is just in those cases, and specifically the one that I think the appellant cited to, or at least in their brief, Tico Energy versus Williams, it talks about where there is a test for acceptance by basically doing nothing, I guess. In this particular case, I'm not aware of anything in the statute that says that. And even the case law I don't think says bought it, but it does imply that you have then are on notice of it and you must, pay and investigate is what it is. But remember, our position is that 120-day rule doesn't apply here. That we never had a situation where we provided treatment or that we were on notice of the osteoarthritis being the major contributing cause because of the way Dr. Goldsmith did not treat and did not put down undetermined as to MCC. And it wasn't until the MCC was determined by the EMA, Dr. Swiggett. You're not going to find any other person, even Dr. Tedder, didn't address, her authorized treating physician didn't address causal relationship between one and between the osteoarthritis and the meniscal tear. He never got around to that because of these series of events, as we indicated in our brief. So what I wanted to, if I may go back to some of these issues that appellant talked about, I think she tried to indicate that the Sanchez case was the one most on point here. And if I could, very quickly, I'd like to go over what the Sanchez case actually states. In Sanchez, the claimant did appeal. It was reversed and remanded. But the specifics in this particular case was there was never any evidence by the employer servicing agent that they, of the specific diagnosis for the admitted compensable injury. So this was a degenerative disc disease as well, but in this particular case, they didn't present any medical evidence that the degenerative condition did not exist in 2016 or could not have been due to the natural progression. That's the only thing we have. I mean,
Yes, and counsel, just wanted to remind you, your time has expired, but I'll give you 15 seconds to wrap up.
okay, so there is competent and substantial evidence, and we should affirm, or we ask this court respectfully to affirm the opinion of the JCC, who got it right and correctly applied the law to the facts that apparently haven't been disputed here.
Thank you, counsel.
Okay, I'll try to cover my thoughts. First would be under 44020 subsection 4, you referenced the word claim. And I do not believe in any of the statute that I've read or in the case law that there is a requirement for the claimant to specifically file a petition for benefits for the osteoarthritis. It is the clock for the 120-day period starts when the employer carrier provides treatment. Okay, and then the question goes
So
to...
is it your argument then that when an employer carrier provides treatment for an ailment, a body injury, anything that comes out of that process, regardless of whether it's major contributing cause related to an industrial accident, they're responsible for it?
Once they get notice that they're providing treatment for a body part or a condition, then yes, then that clock starts. So that there's the hepatitis C case.
They have notice, they're providing the treatment.
Right.
So if they're providing treatment for meniscal tear, how are they required to investigate what may develop or evolve from that body part 1 or 2 years later?
They're not required to investigate an unknown condition, if that's your question. My position here is that they were put on notice when the diagnosis, the only diagnosis, was osteoarthritis. And so Dr. Goldsmith doesn't say, I'm treating the meniscal tear. He doesn't say anything other than osteoarthritis is my diagnosis. He says uncertain whether the osteoarthritis is related to the accident or not, but he says osteoarthritis is the diagnosis. And the court referee is talking about treatment. Well, I think you have to look at the definition of treatment. And this court has defined it. It's not only just in Black's Law Dictionary, but it's also in the Nunez decision, where in the Nunez decision, it says, I'm going to refer to it specifically, that although the doctor did not, so in the Nunez decision, it's dealing with a one-time change decision, but it says, although the doctor did not perform surgery, he saw the claimant on 2 occasions, performed an evaluation, and rendered diagnosis. This is sufficient treatment. That's from this court in 2008. Black's Law Dictionary also defines it as a broad term including examination and diagnosis as well as applicable remedies. It's not that Dr. Goldsmith had to provide surgery. He evaluated, he diagnosed the claimant. He provided a brace. The claimant says he got a brace from Dr. Goldsmith. Dr. Goldsmith says she may have got it from me. Dr. Goldsmith's notes say he provided an injection. When he testifies, he's like, I don't know, might have provided an injection. It's not in my note, but it's in my DWC 25. Claimant says that she got an injection. There's no question about the claimant's credibility that she got an injection. Even if she didn't get an injection, the diagnosis was osteoarthritis as of June 2018. They were on notice.
What after that, so she's entitled to see the doctor, right? She has this meniscal tear. She's going back. She has continued pain. She goes to see the doctor. Certainly it seems reasonable for that visit to be paid for. But what treatment happens after that? What that we can identify as, I think in the context of the statute, as a claim being made in the sense that there's something that is being paid for, there's some treatment that is provided after that.
She sees Dr. Goldsmith again. She sees Dr. Goldsmith again in 2019. She gets a one-time change. She sees Dr. Tedder. Dr. Tedder provides treatment. And it all during this period of time, even if she wasn't seeing the doctor. If the statute of limitations didn't run, their clock is still running. You have to refer to the Bynum transport decision from 2000. That's the hepatitis C case, where this court specifically says the EC cannot evade responsibility or obligation by ceasing to pay or remaining silent. So even if the claimant isn't going back, even if she's just continuing to work as a dedicated servant to her employer for over 18 years, even if she's continuing to just deal with her pain as is, they can't remain silent. There's a duty on the employer carrier, and just to skirt that obligation that they can just look the other way and then decide when they want to deny it. That's not what the case law says. That's not how the 120-day pay and investigate period it was in place by the legislative branch to require there to be some responsibility on behalf of the employer carrier. And here, the responsibility was skirted by the JCC's decision. If the JCC's decision stands, what occurs is that the case law proceeding, which would specifically be the Cespedes case, I'm not pronouncing that right, the Cespedes, Sanchez, and the Sanchez decision, those would essentially be overturned. You would be looking aside from the major contributing cause analysis when there is a clearly compensable condition. That compensable condition is the osteoarthritis. We respectfully request this court to reverse the JCC's decision.
Thank you, counsel. Thank you both. Yes, we will take a brief recess, and we will return for the second case.
All rise.
Please be seated. Our second case today is Millennium Bank, formerly known as Columbia Bank, versus Darby and Peel of Florida Professional Association. Counsel, if you're ready, you may proceed.
Thank you, Your Honor. May it please the court. Nick Polignano on behalf of the appellant. Millennium Bank, which I'll refer to mostly as Columbia Bank, since that is what it was during the course of the events. I hold in my hand the final summary judgment as to defendant Darby and Peel, which is the reason we're here today. And based on everything we know about the law and the facts and concepts of fairness and justice and equity, this judgment cannot really be defended or upheld. And there are three, I'm going to not repeat what we put in the briefs, because I think the briefs on both sides have thoroughly briefed the law and the issues. Let me just give a little bit of a big picture summary of why I think this judgment has to be reversed. The three grounds are really that's illegal, contrary to Florida law. It's illogical, and it's inequitable. So, three reasons. First, let's talk about the law, Silverstrawn case. The final summary judgment cites to the Florida Supreme Court's case of Silverstrawn, but the holding and logic of Silverstrawn are not followed at all. The Brightline rule of Silverstrawn is that the 2-year legal malpractice limitation statute for litigation-related cases begins to run when a final judgment is entered. This bright line has got to be premised, and it is premised, on two things. First, the judgment must be adverse. And second, the client must know or should know that the judgment is adverse. Now, the appellee's brief says that's nowhere in the decision, but it is, that the judgment must be adverse. And in the Larson case in 2009, the Florida Supreme Court clarified that fact. And it says at page 42, 22 Southern 3rd, at page 42, in the Larson case, the Supreme Court says, the crux of Silverstone's reasoning is that it cannot be known with sufficient certainty that the client has suffered any loss caused by the lawyer's negligence until the finality of the judgment adverse to the client. A favorable result for the client in the lawsuit, which could be the result of appellate proceedings, would, of course, mean that the client had suffered no loss. So, let's look at the summary judgment. Paragraph 2 refers to the underlying foreclosure case. Paragraph 3 says that on February 18, 2021, the court entered a stipulated final judgment in favor of Columbia Bank. You go to paragraph 8. The court cites Section 95.11, the statute of limitations, that the malpractice claim must be filed within 2 years from the time the cause of action is discovered or should have been discovered with the exercise of due diligence. Then the first sentence of paragraph 9 of the judgment says that the judgment in this underlying case proceeded the final judgment just like the instant case. In other words, the court said that Silverstone final judgment was just like the final judgment in this case, which is completely wrong because they're completely different. The judgment in this case was favorable to Columbia Bank. In the Silverstone case was an antitrust case in which the court says in the decision that the client knew it was adverse. It was an insufficient damages judgment, and the client knew at the time it was entered that it was adverse.
So, counsel, let me interrupt for a second. So, setting the cases aside, the cases are sort of a tool, a mechanism to help us understand what the statutory requirement is, right, for the statute of limitations. And so the issue ultimately is whether or not the bank could have or should have discovered through the exercise of due diligence the issue, the alleged malpractice. So I have sort of a couple of questions on
Okay.
that. Can you tell us, do you believe this is an issue that the bank could not have discovered through the exercise of due diligence
This is a case where the
at
bank
the time of the final judgment, the original final judgment?
could not have or should not have all of the above, Judge, because the bank has the right to rely on the advice of its attorneys that it hired for that purpose. So the bank was relying entirely on the advice of its counsel, that all properties were included. I think
So the bank has
had-
11 pieces of property, right? A mortgage on 11 pieces of property. 10 of them are foreclosed on. The bank's holding number 11 still, right? It hasn't been foreclosed on. And so at what point through due diligence would the bank recognize that they're still holding this mortgage in their hand?
Well, they've always held the mortgage, but after a foreclosure case, the mortgage is replaced by the judgment of foreclosure, of course. And so at that point, they're not looking at the mortgage. They're just looking at the advice of their attorney that says all the properties have been foreclosed, and now you have a summary final judgment of foreclosure for all your properties. And that's what they understood and believed, reasonably so, because their lawyer said that was the case.
And it goes all the way through, their properties are sold, all of that's done, but it's only to the 10, not to the 11th, right?
Well, I don't think they were all sold. In fact, I don't know if that's really part of the record as to what happened after the summary final judgment. I know this property of the 400 acres was some leased timberland. And so it only really came up when a lease issue arose. And that's when somebody apparently did a Darby and Peel, did a title search, and found that they had missed it. So in 2016, 3 years after the judgment, they tell the bank that we missed it. It's the first time they knew. They thought it had been foreclosed. So
I guess that raises an interesting question, which you seem to be of the position that when a lawyer tells you ABC, you don't really have an obligation to go behind that lawyer's presentation. In other words, and I'm not saying you're wrong, it has a certain logic to it. But a lawyer tells you, yes, we've done the foreclosure, we went to mediation, et cetera, all 11 properties are covered. The bank had no obligation to think, let's double check this just to make sure. Again, I'm not saying you're wrong, but that seems to be your position.
Well, I think they have an obligation to ask the right questions, which they did. In fact, at the beginning, they were very careful and said, this is a confusing mortgage in the whole Lonesome area. And they said, be very careful about check the acreage and check the parcels. And they make specific instructions to Rick Stadler to do that. And so at that point, they've asked the right questions, given the instructions. At that point, they fulfilled that duty, Judge. I think at that point, they have to rely on the advice of their expert attorney to answer the question, which they did. And they were satisfied and had no reason to doubt the advice of their counsel.
And all that goes to the question of whether or not they should have been able to discover through the exercise of due diligence this issue or not.
Well, that's the point that the appellee raises, that the bank should have known better than their lawyers, which I think is not a valid argument.
Well, that's it's important, right? Because that's what we're here for, right? It's whether or not the 2-year statute of limitations was triggered, and to the extent it was, when, right? So the determination about when that point is reached, when through the exercise of due diligence the bank should have known this. Is that a question of fact or a legal question? How is that to be determined?
It's really not in dispute here. It was learned in July 2016 when they got a call from Bonnie Green saying.
That's when they had actual notice.
Actual notice.
Right. So but.
Oh, they should have known constructive knowledge?
So it does seem to me that everybody agrees that the actual notice was in 2016, right? But the dispute is about whether or not they should have known, the bank should have known before.
I don't know that you could have reasonably, anybody should have known that their lawyer's advice was wrong.
So who decides that? How do we decide that? Is that a question of law or is that a question of
Well,
fact?
if you get to that issue, and maybe in the brief, it's a issue of fact for a jury, which precludes summary judgment on that issue. So if that becomes an issue, and if you send it back to the trial court as to constructive knowledge, that would be a factual dispute.
Aren't we significantly hampered here? We're here on an appeal of a final summary judgment. We don't have the transcript for the summary judgment hearing. We don't know what the trial judge found. We don't know the questions. We don't know the arguments made. We don't know if some of these factual disputes were discussed, and what was found on the record, which the rule allows the trial court to make lots of findings on the record that don't all have to find their way into the final summary judgment. With respect to at least your third and fourth argument, isn't the absence of the transcript in this record fatal to your claim?
No, Your Honor, because you do have the briefs, and the briefs, they were thoroughly briefed on both sides. So that is part of the record.
The briefs?
The briefs in support and in opposition to the motion for summary judgment.
Right. So, but what we're trying to test whether the trial court's ruling, was either legally sufficient or an abuse of discretion, or whether there was competent substantial evidence. Isn't the transcript a very important component of that?
It's just argument of counsel. No, I don't think so. It wasn't an evidentiary hearing. It's just affidavits, arguing the same record that this court is hearing today.
But we have no way of knowing that, right? Because we don't know what was discussed in that hearing.
We know it could only be the record that's before this court. We know that. It can't be anything outside that record. If it was, it shouldn't have been considered. So it's not an evidentiary hearing. It's a summary judgment hearing. So the same documents were before that court that are before this court, and this is a de novo review. So this court should look at it the same way Judge Fiegel looked at it.
Thank you.
The next distinction of Silverstrawn is the transactional aspect. And we do know that this court completely ignored that part of the claim. Silverstrawn was an antitrust case. This is a foreclosure case. I don't think any court has ever interpreted Silverstrawn in the context of a foreclosure. And foreclosure is different from antitrust. Every foreclosure has transactional components. Ordering the title search, examining the record, preparing the notice of lis pendens to make sure that your property can't be superseded by another lien. The transactional failures of Darby and Peel, in this case, are well documented in the record. They did not consult with the Columbia Bank. This is from the expert Laney Russell. Did not consult with Columbia Bank about purchase of a title policy. They based the foreclosure judgment or complaint on a title search report. It wasn't a commitment for title insurance. That may have made a difference if they had asked for a title insurance commitment. With a commitment, the bank has the option to buy title insurance, and all this would have been insured. None of that happened. That's the first transactional problem. Then when they drafted the notice of lis pendens, they left out this parcel. Whether it was their fault or First American's fault, doesn't matter. They had the obligation to check First American's work, which they didn't do. So all these transactional components were totally overlooked by the trial court. So for those reasons, it's contrary to Silverstrawn, the reasoning, the logic of Silverstrawn. This judgment just takes the tack that the judgments are exactly the same, the result's going to be the same. The next reason it makes no sense is that that result is illogical on its face, because it determines that the limitations ran before anybody knew about a claim. And that makes no sense at all. It ran before even the attorneys who committed the malpractice were aware of their malpractice. If you look at that in light of the statute of limitations, Section 95.11 states the 2-year limitations for professional malpractice shall run from the time the cause of action is discovered or should have been discovered with the exercise of due diligence. Here we've been to the constructive knowledge, but again, that is an essential part of Silverstrawn and that is ignored by the court in this case. Because there's no discussion at all about knowledge of the decision of whether a malpractice claim had occurred. And again, we said it was first discovered in July of 2016. That's a fact, and we all know that. The proper application of Silverstrawn in Section 9511 shows the limitations began or did not start until March 2019 when the bank's appeal was concluded. That's the time that we know the bank knew of unredressable harm caused by the lawyer's malpractice. The third ground is inequitable. And although I know legal malpractice is not a case in equity, the Florida Supreme Court has stated that the two concepts of statute of limitations and equitable estoppel work hand in hand to achieve a common goal, the prevention of injustice. And that's the citation from the Supreme Court case of Morsani versus Major League Baseball. It's not in our briefs, but it's at 790 Southern 2nd, 1071, 2001. And the point of that is that concepts of fairness and equity must be considered in applying a statute of limitations, which was not done here. This judgment is inequitable, unfair, and unjust for many reasons, where neither the client nor the attorney was aware of the omission until more than 2 years after the original foreclosure judgment was entered. It basically eliminates a malpractice claim before it arises. It also states that a client is required to double-check its advice of its attorneys. It's never, under the case law that's cited in a brief, it's never a client's responsibility to do that. That's the Tarleton case that was cited. I can respond to the other points that were raised by the appellee, or I can wait for my rebuttal time, so
You'll reserve the remainder?
I'll reserve the remainder time for rebuttal. Thank you.
Thank you, counsel.
Apologize.
Absolutely.
I've had a call for about, I've tested negative, but I've had a call for about the last 3 weeks.
Take your time.
I want to try not to get up in the middle of my argument and break out into a massive cough fest. So may it please the court. My name is Robert George from the Lyles firm, and I'm here today on behalf of my clients, the Darby Peel firm from Lake City, Florida. They were the defendant in the malpractice action. And the movement of the motion for summary judgment, which was granted, and which is why we're here today. Just as note, the motion for summary judgment was limited strictly to the issue of statute of limitations, and I'll try to contain my arguments related to that very issue and not get into any of the substantive arguments. But with that said, I know my client would like for it to be known that they strenuously deny any and all substantive allegations as it relates to liability and or damages. But with that said, the statute of limitations, I don't think there's any doubt that the statute of limitations defense that was raised in this case is initially prescribed and controlled by Florida Statute 9511-4A that says that actions for legal malpractice must be brought within 2 years, quote, from the time the cause of action is discovered or should have been discovered with the exercise of due diligence. Now, this standard or determination was addressed in the Silverstrawn matter, and that was Florida Supreme Court case in 1998. And in that case, the court specifically held when a malpractice action is predicated on errors or omissions committed in the course of litigation, and that litigation proceeds to judgment, the statute of limitations does not commence to run until the litigation is concluded by final judgment. To be specific, we hold the statute of limitations does not commence to run until the final judgment becomes final. The court goes on to reaffirm that statement, stating, we therefore hold in those cases that proceed to final judgment, the 2-year statute of limitations for litigation-related malpractice under Section 9511(4A) begins to run when the final judgment becomes final. This Brightline rule will provide certainty and reduce litigation over when the statute starts to run. Without such a rule, the courts would be required to make a factual determination on a case-by-case basis as to when all of the information necessary to establish the enforceable right was discovered or should have been discovered. And Judge Long, I would go back to the question that you asked, is this a factual question or a legal question? I think after the Silverstrawn decision, this became a legal decision to the extent it fits within the parameters of that opinion, which we argue and assert clearly falls within those parameters. The court, I think what's important, went on to address when a judgment becomes final in their second footnote, where they say a judgment becomes final either upon the expiration of the time for filing an appeal or post-judgment motions, or if an appeal is taken, upon the appeal being affirmed and either the expiration of the time for filing motions for rehearing or a denial of the motions for rehearing. At that point in time, a decision is final. Doesn't matter what happens after that time. Pursuant to this case of the Florida Supreme Court, once that time has passed, that judgment is final, and that's when the statute of limitations runs. I will acknowledge that there have been 2 limited and very narrow exceptions to the Silverstrawn Brightline rule. The first was about 10 years later in the Larson & Larson decision, when the Florida Supreme Court addressed a situation where there was a conflict between 2 cases. Just like in the Silverstrawn, there's a conflict between 2 cases, both of them litigation related. But the in the Larson & Larson, there was a judgment, and then there was a subsequent sanctions awarded by the court. And one of the cases before the Supreme Court in the Larson matter had said the statute of limitations begins to run in the final, when the final judgment is entered. Didn't matter about the sanctions. And then the other court had said it didn't run until the sanctions had been determined. And in the Larson & Larson matter, Supreme Court decided that that in those cases, those sanctions were discrete and separate from the final judgment. And so, in essence, they bifurcated it and determined that there was actually 2 separate counts for legal malpractice. And the counts as it related to the final judgment, those had been barred by the statute of limitations. Those as it relates to the sanctions were still viable. The only other exception to the Silverstrawn Brightline rule was just a year or 2 ago by the Southern District of Florida in the McIntyre matter, or McAteer. And that case was unique in the fact that the attorney, who was the defendant, had entered into a stipulated default judgment or deficiency judgment. And it was the client's testimony that they had no idea, they were completely unaware of the judgment. And it wasn't until collection matters were taken that's the first time they were actually aware that there was an adverse judgment. And so in that case, the Southern District, they cited to Silverstrawn, they cited to Larson & Larson. But what they also looked at was the standard jury instruction. And the notes to that standard jury instruction for 402.14, which said, and again, in illegal negligence actions predicated on acts committed in the course of litigation The statute of limitations does not begin to run until the underlying litigation is concluded by final judgment in the final disposition of any appeal. And they cite to Silverstrawn. But then it states, this may be extended if there is an issue regarding whether the client knew or should have known that the litigation was concluded. They don't get into whether it was adverse or the word adverse is not even in there. It is whether the client was aware it was concluded. And in this case, neither one of these exceptions apply because there's no issue of sanctions or any type of supplementary proceedings. All the damages.
So your argument is, under the statutory scheme as interpreted by the Supreme Court, once that final foreclosure judgment was entered, and remind me, I don't think there was an appeal of that.
There was no appeal, Your Honor.
So it'd be 30 days after that judgment was entered. It's final. The burden then shifts to the plaintiff. You have 2 years to
Yes, Your
decide whether there was malpractice.
Yes, Your Honor. And again, as it relates to the fact of the standard jury instruction, the comments to that, there is no doubt that Columbia Bank, and as opposing counsel did, because Columbia Bank was the name throughout the whole litigation. I'll name it
Here,
Columbia Bank.
there was later litigation where the parties attempted to sort of rescue the lost property, and your argument is that that has no relation to the finality.
Has no relation whatsoever to, again, there's no supporting law whatsoever that once that judgment becomes final, you can somehow revive it. And in fact, that's what happened here. They tried to revive a judgment that was final, and their attempts were denied by the trial court and denied by this court. And so just because you try to revive
So
an action.
under the scheme as interpreted by the Supreme statutory scheme, your argument has to be, doesn't matter what your lawyer tells you. Your lawyer can tell you, hey, we did a great job, you got $1 million verdict, you should be getting a check in the mail any day for $1 million plus interest. The client has an obligation of due diligence for a 2-year period to go behind because your learned opponent is arguing that you can rely on the lawyer's advice.
Your Honor, once a judgment becomes final in the Larson decision, the Supreme Court specifically declined to adopt the continuing representation doctrine, and the court specifically held that once a judgment has been reached to the point of finality, there is no justification for tolling the statute of limitations,
Including equitable estoppel.
including equitable estoppel. They were pretty clear there is no justification for
What
it.
is your response to the Chief Judge's question whether the lack of a transcript is fatal on issues 3 and 4? Or do you not disagree with your learned opponent?
I'm not really sure what you mean by issues 3 and 4, but I will tell you that
On the summary judgment, in other words, is it an Applegate issue where the lack of a transcript is fatal?
I don't know if it's fatal. I think that it could,
Or is it your argument, sorry to interrupt again, but is it your argument that, hey, 2 years elapsed from the final judgment, we went on all counts? That's game over.
that is my argument, Your Honor. I mean, pursuant to and again, this is the Supreme Court that defined it as a bright line rule. They didn't say it's a rule that applies in some case. Right? They created that rule for a reason to eliminate cases, an analysis like Columbia Bank is trying to have happen in this case, where it's a case-by-case analysis to determine when you should have known it was adverse. First of all, I want to be real clear about that Columbia Bank is trying to carve out with the word adverse another exception or another limitation to the bright line rule of Silverstrawn. That's nowhere else. I mean, they're trying to say that you have to show that the client knew it was adverse. First of all, they're saying that it has to be adverse, which in some way I think they're saying it's against them. But even one of the decisions that was being reviewed in Silverstrawn, the verdict was actually in the client's favor,
But Silverstrawn is quite different from what we're talking about here, right, factually. So in Silverstrawn, there's no dispute about the client's knowledge of the alleged malpractice. The issue happened during trial, was that, and ultimately the dispute was about whether or not the point that triggers the statute of limitations is the verdict that's rendered or finality, right? And so the idea wasn't about, there was no dispute about whether or not they knew about it. And here we have a different situation. We have a situation where they're claiming that they didn't know about the alleged malpractice.
Your Honor, the issue is whether they knew about the judgment. And there is no dispute that Columbia Bank received.
So essentially, your argument is, in response to my learned colleague, your argument is, look, if you're involved in litigation, if you're involved in the legal system, and you get a judgment in your favor or against you, you sort of have an obligation to hire a different counsel if that's your inclination, whereas here it would have been the in-house counsel, I guess, to say, double check this. We have this judgment. It's a complicated mess, if you will, and let's make sure we've got all our parcels covered. And you have 2 years. That's it. No exceptions other than the ones you've mentioned.
That is my position, and I believe that is the clear law in the state of Florida as we sit here today.
And assuming that's the case, is there any procedural deficiency akin to the ones that are raised in issues 3 or 4 that could create reversible error, particularly when there's no transcript of this hearing?
No, Your Honor. And again, now that I understand you're saying 3 and 4 in this brief, the issue as it relates to the, and I don't remember which one was 3, which one was 4, but as it related to the basis for the ruling, the judge contacted both counsel, asked for proposed judgments, which were submitted, and I think the email even kind of said for consideration. And the judge was free to review those, accept them, reject them, draft his own. And in this case, he accepted based upon the clear facts that were not in dispute as to when a judgment was obtained and the law in Silverstrawn. As it relates to the other factor about the timing of the memorandum, again, I don't think there's any issue whatsoever right there. That issue was discovered by myself and Mr. Sheftal, who's in attendance here today, when the scheduled hearing was within the 40 days. There was communication of we need to move the hearing back, and Mr. Sheftal said I'd rather not move the hearing back. Both parties agreed to a briefing schedule, and so to the degree they have any objection to that now, it's kind of like they've waived that. They agreed to the briefing schedule. They had an opportunity to object to it. In fact, I personally am the one that said we need to move the hearing back, reschedule it so we have plenty of time. And at Mr. Sheftal's request, we decided to go forward with the hearing and just have a briefing schedule.
Well, let's answer a hypothetical. Assuming that they're correct, that there was a lack of procedural compliance with Rule 1.510C, is there anything in that error that would give rise to a reversal in this case?
No, Your Honor.
Is there any authority that would suggest otherwise?
First of all, I do believe the two issues, the judgment that was rendered by the court, I'm not aware of any authority that says the judge has to state outside of the final judgment the basis for his decision. And so as it relates to the final judgment that was entered has findings of fact, findings of law, and a determination. As it relates to the timing of the memorandum, again, those were counter to what is set forth in the rules of procedure. However, any arguments about that formality was waived by opposing counsel when they agreed to go forward, as opposed to rescheduling the hearing.
Well, it's not real complicated in this case anyway.
I don't think it's very complicated.
Either the Supreme Court case law compels a ruling to affirm that lower court, because the final judgment, which was not appealed, triggered the 2-year time frame, or didn't.
Yes, Your Honor, I agree. And I will say there is one other issue that was not raised by opposing counsel's argument, but it was kind of raised a little bit in their briefing. First is relates to the issue of redressable harm. There were, and again, the Columbia Bank is trying to argue that that the Brightline rule of Silverstrawn should not be applied. One, because they don't believe it was adverse; they didn't know it was adverse. Or number two, that the action was not final until the appeal. And then number three, because that it was transactional in nature. Columbia Bank cited to 3 cases in their briefing as it relates to the transactional argument. However, I think those cases are important to distinguish from the instant case. Those cases are the Waltz versus Getz matter, the Brook, get my glasses on, sorry, the Brook versus Shoemaker decision, and the Spivey versus Trader decision. And even though those were cited for the purpose of transactional versus litigation related, those 3 cases based their opinion on the fact of redressable harm, about when there was redressable harm. In just to give a little factual background, the Waltz case, or the Getz case, was a family law dispute where there was a prenuptial agreement that includes some limitations of how post-divorce support could be modified. They entered into a mediated settlement agreement that restricted that. And once after the divorce was completed, the former wife began to have a relationship with another man, and the husband then became aware, because there's a supportive relationship, I can't try to modify my spousal support. In the Brook matter, it was a case where a lawyer had.
But that 2-year time limit in the other case triggers when the former husband finds out about the supportive relationship.
Well, it goes to redressable harm. In all these cases, there were supplemental proceedings that caused the damage. So in the Getz matter, it wasn't until the wife entered into that relationship that it caused the redressable harm. In the Brook, there was a lawyer advised a client to enter into a default judgment so that it could then be discharged in bankruptcy. It wasn't until the bankruptcy court refused to discharge that there was redressable harm. In the Spivey matter, there was some asset protection advice, and it wasn't until the court determined that those assets were subject to execution that there was redressable harm. In this case we have here, the redressable harm happened as soon as that final judgment was entered. The supplemental proceedings in this case.
Your argument has to be, you don't look at redressable harm here because you have a final judgment and it's litigation malpractice.
Well, 2 of those cases were determined after Silverstrawn, and I think that is the issue of when there is redressable harm.
Are either of those cases remind me from our court?
They were not, Your Honor.
Okay, then they're not controversial.
One of them, the Spivey decision, was determined pre-Silverstrawn, but then the Brook decision was 2002, and it was the second DCA, and then the Watts versus Getz was also the second DCA.
And those cases aren't binding.
But again, the point I would like to make, though, is in this case, the only supplemental proceedings that took place, nothing happened as it related to the damages. In fact, it was just trying to kind of revive. And if I could just,
Counsel, you're a minute over. I'll give you 15 seconds to wrap up.
I do just want to point out there was a quote in the reply brief that, and I'm sure it was an honest mistake, it was taken from the head note and it included in there, and they highlighted it, which concluded with an adverse outcome to the client. That was from the West head note. The actual opinion does not include that in there. So
Thank you, counsel.
So the adverse, again, I would just say is not determining, it's the conclusion of the matter.
Thank you. I'll ask the clerk to add 2 minutes for the appellant.
Thank you, Your Honor. I have 5 minutes.
Yes,
May it please the court. Judge Thomas is correct. This Silverstrawn makes no sense in the context of this case. No sense at all. Because this was a foreclosure case. The underlying case is very important, the distinction between the antitrust and the foreclosure case.
And I appreciate your argument, but it doesn't seem like they said that.
Well,
They
they don't.
established a bright line rule, and I don't understand how it matters what type of case it is.
Well, the foreclosure case, courts typically reserve jurisdiction because foreclosure cases have a lot of post-judgment events that happen.
Right,
Like
deficiency
sales,
judgments.
deficiency judgments and sales and all sorts of things.
But in this case, all deficiency judgments were waived, right?
They were, but reforeclosure is typically filed in foreclosure cases. And that is the court reserved jurisdiction for reforeclosure, which
But-
this judgment didn't say that Mr. Stadler drafted. If the court had specifically reserved jurisdiction for reforeclosure, we wouldn't have this issue today. There's another instance of his malpractice.
So you're saying the foreclosure judgment wasn't final?
It's completely different. It's not final. When it says final, it's not completely final. Courts reserve jurisdiction in every foreclosure case. And this one did retain jurisdiction. It didn't say specifically for what things, but it did reserve jurisdiction. So it wasn't final. And so this appellate, these proceedings that happened for reforeclosure are important and are just glossed over as unrelated, but they are related. And the trial court did accept jurisdiction, ruled on those motions. It came to this court. This court did a PCA, but didn't say there's no jurisdiction. Jurisdiction was accepted, and the appeal was denied. And that's the date that that judgment became final.
That's your 2-year clock.
That's the date it became
The
final.
PCA, the mandate on our
Correct.
PCA is your 2-year clock.
That's correct. That's when. But even if it wouldn't have become final then, we found that before, within 2 years of the date, the malpractice was discovered. So even if the court finds that judgment was final earlier,
But I don't see that
If
leeway.
you-
I don't see that leeway in Silverstrawn.
I do, Judge, the adversity is the important point.
But they didn't say that.
They do say, in their cases they cite, that adversity of the judgment is important. And then
So in a hypothetical, the lawyer tells a plaintiff in a personal injury case, great news, we got $1 million judgment, and you're going to be rich. And so more than 2 years later, after the judgment, and maybe even after receiving the compensation, another lawyer tells that plaintiff, you could have gotten $5 million easily. Your lawyer undersold your case. He was negligent. He didn't take depositions. What happens there?
Brightline applies to that one, obviously. That's easy. This is different case.
So what exclusions do you see? I assume you would say all family law cases, they never seem to be final. No offense, I don't mean to be flippant.
Well-
But I mean, those cases go on for years.
Well, Silverstrawn did exclude transactional
Right.
events, which this foreclosure really is. It becomes a foreclosure.
But isn't a transactional event, I'm just asking again, I'm not necessarily disagreeing. Wouldn't a transactional event be, say, a contractual matter? Or, like you mentioned, a title commitment? You know, something that did not involve litigation and a final judgment.
It still can involve litigation, which it does in every foreclosure, because it involves a real estate transaction at the end of it. That's what it is. It becomes a transaction at the end of foreclosure. You own the property, you have to sell it.
So in your view, what cases, what kind of final judgments does Silverstrawn apply to?
The kind of case where the adversity of the judgment is obvious and obviously known. This circumstance is very unusual. I mean, you're not setting any dangerous precedent by reversing this judgment, because how often does this happen? It never happens, where you have a lawyer that misses a 400-acre parcel and nobody knows about it for 2 years. I mean, it's a very unusual factual scenario. So under these particular facts, peculiar facts, Silverstrawn makes no sense. I don't think the Supreme Court would have applied that rule under these facts, because it makes no sense. It's illogical. It's unfair. It's inequitable. All the reasons. And Judge Wright, I didn't understand your questions about issues 3 and 4. You meant the procedural defects, and we put those at the end because we'd really like the court to rule on the merits, so we're not back on a procedural issue only. It is a defective procedure. There's no question about that. The email just says, I'm granting the motion. Typically, the judge in an email outlines the reasons so the lawyer can put that in the order. We had no reasons at all in this case. So we don't know if the judge had ruled at the hearing with the transcript, we would have known, but he didn't. He waited 3 more weeks to issue his decision. And he just said, I'm granting it. It's procedurally defective, no question about that.
Thank you, counsel. Your time has expired.
My time is up? Okay,
Yeah.
thank you.
Thank you all. This court will stand adjourned.
All right.
Thank you very much.